is in the matter of Begum and the Secretary of State for the Home Department.
May it please your ladyships, your lordship, I
Yes,
appear
thanks.
on behalf of the appellant together with Mr Dan Squires, King's Counsel, Aisha Christie, Tim James Matthews and Julianne Morrison. For the Secretary of State, Sir James Eadie, King's Counsel, Jonathan Glasson, King's Counsel, David Blundell, King's Counsel, Jennifer Teelan and Carl Laird. And the special advocates are Mr Angus McCulloch,
Yes.
King's Counsel, and Mr Adam
Quite a
Straw.
roll call. Thank you very much indeed. Yes.
The bundles, there's always some housekeeping,
Yes.
but this is very short and straightforward. Core and supplementary bundles, obviously the court has. There are 3 authorities bundles,
Yes.
and then there is a clip of some additional authorities which are in the skeletons but did not make their way into the agreed authorities bundle. So those just need to be added to the end of the third authorities bundles, tab 72.
The latest version we have goes up to tab 71.
Yes,
Is
my
it
lord,
more
so
than that?
72 and 73 only. And there it is,
Mine
replacement
goes up
index.
to 68. Am I missing something?
Oh, yes, you are, my lady, and we will seek to rectify that. For my part, I don't envisage turning to any of those later authorities in my submissions, but we'll make sure that that is rectified. And if necessary, we can hand it up this morning.
Thank you. Yes.
The timetable's obviously agreed, and in terms of the split, today I'm going to deal with grounds 1 and 2, trafficking, and my learned friend Mr Squires is going to deal with de facto statelessness, procedural unfairness, and the public sector equality duty, and we will wrap up within the day today.
Good.
The submissions on trafficking can be summarised as follows. The appeal is brought on 2 distinct trafficking grounds. The first concerns the legal obligations owed to victims of trafficking and potential victims of trafficking pursuant to Article 4 of the Convention, which are relevant consideration in deprivation decisions concerning potential victims of trafficking. These do not impose an absolute bar to deprivation, and it's very important. That is a theme of our submission below and before this court, contrary to the Secretary of State's characterisation of our case. However, we do say that the Secretary of State was required to consider these legal obligations under Article 4 and whether deprivation would frustrate or impede the state's ability to discharge these obligations, and if so, whether this could be justified before making the decision to deprive. And the failure to so consider breached Article 4 in this case. The second ground.
I would be assisted, as and when we get there, I'm sure you will, by real clarity as to characterising what it is you say the Secretary of State should have taken into account precisely. I want a formulation of it, in what way it impeded, and then justification obviously is a judgment point.
Absolutely, my lady.
Just outline that, that'd be very helpful. Thank you.
I will come to that. The second ground is the common law ground, and we say that the appellant's trafficking and the state failures, the compliance with the legal obligations arising therefrom, failure to investigate were mandatory relevant considerations in determining whether deprivation was conducive to the public good and proportionate, and it was irrational for the Secretary of State not to consider them. And so again, no absolute bar to deprivation, but an irrationality argument. Dealing then with the Article 4 submissions, I make submissions under 4 headings. First of all, the legal obligations owed to victims of trafficking and potential victims of trafficking under Article 4. Secondly, the legal obligations which arise in the appellant's case. And thirdly, the relevance of the obligations to the lawfulness of a decision to deprive, and I'll deal under that heading with the errors that we say the Commission fell into in its judgment. And then fourthly and finally, I'm going to respond to the Secretary of State's arguments about jurisdiction. So dealing first of all then with the legal obligations.
So that's the respondent's notice point, you mean?
Yes.
Yes.
Dealing first of all with the legal obligations owed to victims of trafficking and potential victims of trafficking. Some preliminary observations which are not contentious. Article 4 obviously doesn't textually deal with trafficking, but it's accepted by the European Court to apply to trafficking equally as it does to slavery. Secondly, the prohibition in Article 4 is an absolute and non-derogable.
It's going a little bit fast for me, at least.
I'm sorry,
No.
my lady.
So, legal obligations accepted that they apply to trafficking. Yes.
Secondly, the Article 4 prohibition is absolute and non-derogable. The definition of trafficking that the European Court has adopted is that contained in ECAT, Article 4, the European Convention Against Trafficking. And the obligations that Article 4 places on the state towards victims of trafficking and potential victims of trafficking are aimed at protecting and preventing trafficking, identifying those who've been trafficked, and they are triggered by the existence of circumstances giving rise to a credible suspicion that an individual has been or is at real and immediate risk of being trafficked or exploited. And that credible suspicion, again, this is not contentious, is a low threshold. The Commission rightly noted Lord Justice Underhill's observation in the Court of Appeal decision in TDT. It's, I suspect, but cannot prove.
Sorry, Ms. Knight, you said a moment ago that the Article 4 obligation is absolute and non-derogable. What do you mean the obligation is absolute?
Well, there is an absolute prohibition on slavery. The obligation we're relying on in this context is a procedural one. It's the failure to consider the Article 4 obligations, but the prohibition is an absolute one. There is a prohibition on slavery, similar to the prohibition on torture in Article 3, although there will be procedural aspects of the Article 2 and 3 which we say are akin to the Article 4 obligation. So it's a procedural aspect that we're looking at in this case. It's a failure to consider the Article 4 obligations.
Right.
And that's absolute, you say? You rightly said the prohibition is absolute. Is
Yes.
the obligation absolute?
Well, the failure to consider is a breach of Article 4, we say in this case. Yes. There are, under the Article 4 rubric, there are essentially three categories of obligations. Only two are in issue in this case, the investigative and the operational obligations. There is a third category which one sees in the case law, which is a systems obligation, which is to do with the putting in place a legal framework and an administrative framework. That's not an issue in this case. In terms of the investigative obligation, that involves an obligation to identify victims and potential victims and to conduct a full and effective investigation into the circumstances of their trafficking. There is a separate operational duty, and there are three aspects of this. First of all, there's a protective obligation to identify individuals at risk and take reasonable steps to prevent their trafficking or re-trafficking. There is a recovery obligation, which looks at the physical, psychological and social recovery of victims, those who've been victims who've been trafficked, and the duty aims at rehabilitation as well as preventing the re-trafficking. And thirdly, there is a non-punishment principle which forms part of the operational duty. We say this is not limited to a criminal prosecution, but applies equally to adverse measures, penalties taken against victims of trafficking and potential victims of trafficking in relation to acts connected with their trafficking and which impact on their recovery or protection. There are three key authorities, Strasbourg authorities, which I want to take the court to, and then I shall build my submissions on those, referencing, where necessary, some additional authorities. But it's important to have in mind at the outset Rantsev, SM Croatia, and VCL. So the first authority I'm going to take the court to is Rantsev. In the third authority bundle, tab 62, or electronically, it's page 1951. This was a case about a Russian national who'd been trafficked from Russia to Cyprus on an artist visa to work in a cabaret. She escaped from her trafficker in Cyprus, but she was found, she was taken to the police, and she was returned back to her employer trafficker. The following day she was found dead in the street below the apartment that she'd been left in. And the court was asked to consider whether there had been violations of Articles 2, 3 and 4 by Cyprus and by Russia. The findings we can see, they're just recorded at page 8 on page 1952. So we can see that there's an article, breach of Article 2, investigative duty, breached by Cyprus. That's little 5. There is a violation of the protective duty by Cyprus. That's subsection 8. And then 10, and this is important for our case, there's a violation by Russia of its procedural obligations under Article 4 to investigate the alleged trafficking of this Rantsever. The general principles I can take quite quickly. Don't understand those to be contentious, but they begin at page 2012. And I make passing reference to paragraphs 282 and 283, which records the trafficking definition and the principle that there's no provision for exceptions and no derogation, which I referred to. Paragraph 285 deals with the systems duty, which is not an issue in this case. Paragraph 286 deals with the operational duty to protect victims and potential victims. And as I said, the trigger is a credible suspicion, circumstances giving rise to a credible suspicion that the individual was at real and immediate risk of being trafficked. And there's a violation where the authorities fail to take appropriate measures to remove the individual from the risk. And then just going on 287, noting that the obligation, this is the second or third sentence in 287, the obligation to take operational measures must, however, be interpreted in a way which does not impose an impossible or disproportionate burden on the authorities. And then going over to 288, this deals with the investigative obligation. And the reference is that, like Articles 2 and 3, Article 4 also entails a procedural obligation to investigate situations of potential trafficking. It doesn't depend on a complaint from a victim or next of kin. Once the matter has come to the attention of the authorities, they have to act of their own motion. The investigation has to be independent, capable of leading to the identification and punishment of individuals responsible. It's an obligation not of result, but of means, with a requirement of promptness and reasonable expedition. And where the possibility of removing the individual from the harmful situation is available, the investigation must be undertaken as a matter of urgency.
What does an obligation not of result but of means mean?
Well, it means that obviously you can't, it envisages that what the state is required to do is to take all reasonable steps to investigate. It may be in some situations, of course, that you can't actually identify perpetrators, you can't prosecute somebody, but that does not absolve the need to carry out the investigation. So it's not presupposing what the result of the investigation might be. There will be situations, as I say, where there won't be any prosecution arising as a result of the investigation. And then 289, and this is significant, this paragraph, for our jurisdictional link and the connection with Article 4 in this case, notwithstanding that Ms. Begum is now outside the jurisdiction. 289 says, the court reiterates that trafficking is a problem which is often not confined to the domestic arena. Where a person is trafficked from one state to another, trafficking offences may occur in the state of origin, any state of transit, and the state of destination. Evidence and witnesses may be located in all states. Although the Palermo Protocol is silent on the question of jurisdiction, the Convention, Anti-Trafficking Convention, explicitly requires each member state to establish jurisdiction over any trafficking offence committed in its territory. Such an obligation is, in the court's view, only logical in light of the general obligation outlined above, incumbent on all states under Article 4 of the Convention to investigate alleged trafficking offences. So there is an obligation to investigate trafficking which occurs within the jurisdiction of the state, irrespective of whether the victim of trafficking has indeed left the state. That is the jurisdictional link which we rely on. There is no extraterritorial application or exception, if you like, that we're relying on in this case. It's a jurisdictional link because trafficking began in the UK and there was a credible suspicion that she was a victim of trafficking, which was triggered before she departed. Going then to the application, the court's application of the principles, and this goes over the page to 216, I can deal with the application in respect of Cyprus fairly quickly. That's set out at 294 to 298. There was a breach of the Article 4 protective duty by Cyprus. That was because there was, it was clear on the evidence that there was a serious problem with foreign women being recruited to work in the sex industry, and the authorities were aware of this, and there were sufficient indicators available to the police obviously having had custody of Miss Rantsaber at one point, that she was at real and immediate risk of trafficking. But in relation to Russia, which begins at paragraph 301, the court looks first of all at the positive obligation to take protective measures in relation to Russia. And the court, this is 304, the court recalls that any positive obligation incumbent on Russia to take operational measures can only arise in respect of acts which occurred on Russian territory. And on the facts of this particular case, when Ms. Rantsaber left Russia, the court notes that although the Russian authorities appear to have been generally aware of a problem of young women being trafficked, there's no evidence, unlike our case, that they were aware of circumstances giving rise to a credible suspicion of a real and immediate risk to Miss Rantsaber herself. So they were aware of a generalised problem, but that wasn't sufficient. They needed to be aware that there was a credible suspicion of a risk to Miss Rantsaber herself. And it says it's insufficient in order for an obligation to take urgent operational measures to arise, merely to show that there was a general risk. Insofar as this was concerned, the court recalls that the authorities took steps to warn citizens of trafficking risks, and so they conclude that there was no positive obligation on the part of the Russian authorities to take operational measures. The position, however, would, on the analysis of what the court is saying, be different if a credible suspicion had arisen before Miss Rantsaber left Russia. In those circumstances, the court would have examined the operational duty and considered whether the state did everything it took all reasonable steps to do what it should have done to prevent her from trafficking, to protect her from trafficking. So in principle, it's very clear that the operational duty would have been considered, notwithstanding the fact that Miss Rantsaber is outside the jurisdiction at this point. But it didn't arise on the facts. Then looking at the investigative obligation, and that begins at 307, Notwithstanding its finding in relation to the operational duty, the court does find that there was no investigation into how and where Miss Ransaber was recruited. This is paragraph 308. In particular, the authorities took no steps to identify those involved in her recruitment or the methods of recruitment used. The recruitment having occurred on Russian territory, the Russian authorities were best placed to conduct an effective investigation into Miss Ransaber's recruitment. The failure to do so in the present case is all the more serious in light of her subsequent death and the resulting mystery surrounding the circumstances of her departure. And therefore there was a violation of Article 4. And the obligation therefore was not extinguished because Miss Ransaber had left the jurisdiction or had died.
No, but it does suggest, doesn't it, as I read it anyway, that you can have a full and effective investigation without the complainant, as I might call them, being present, because Miss Ransaber wasn't there, she's dead, but Strasbourg was still saying Russia had an obligation to investigate. So there is a disconnect, isn't there? I mean, the notion of a full effective investigation, you need to help me with this, doesn't necessarily assume the presence or even the contribution of the person who may have been trafficked.
Absolutely right. It's fact specific, but there will be investigations, as we can see in the case of MS Pakistan in the Supreme Court, where it is necessary for an individual to participate, to have a full and effective investigation. But you're absolutely right, Your Ladyship.
It may all depend. I mean, MS Pakistan, you had somebody who was physically here with no national security issue, I think, in play at all.
Well, and somebody who was alive.
Somebody who was alive.
Here, of course.
And where criminal prosecution, as I read MS, whether you're looking at criminal prosecution, in which case you are best placed if you have a complainant. But that's not, I think, what's being talked about by the Strasbourg court in Ransaber, is it? It's a different sort of investigation.
Well, it's a full
Hydra investigation.
Yes, exactly. It's an investigation which is owed to society at large. It's not an investigation which is owed just to the victim or to the victim's family. There's a societal purpose in carrying out investigation, as there is with Articles 2 and 3 of the Convention, to understand what went wrong, were there, for example, state failures, what lessons can be learnt. So it's that wider. So in some instances, it may not be necessary to have the victim participating in that. Although if the victim is alive, the expectation would be that the victim would participate in some way. And of course, in the situation where we're looking at here, which is an individual who was groomed and coerced through online media and means, it would obviously be very relevant to be able to ask the victim herself how she was groomed, how she was coerced, who was corresponding with her, who sent her messages.
Is there a temporal limit on the duty?
No.
Does it go on forever and ever and ever?
Well, it goes on until the investigative duty it doesn't have a temporal limit per se, and in fact, on the facts of Miss Ransaber's case, the events happened in 2001 and it comes to the court in 2010, some 9 years later. But of course, the passage of time will no doubt influence the scope of the investigation and what can be done. But the duty per se doesn't expire because of time. Otherwise, of course, the state would be able to take the benefit of just not doing anything, not acting expeditiously, and then saying, well, it doesn't matter, time has now elapsed, and there's nothing that can be done.
Do we know in this case, and again, I may be jumping ahead, and you must tell me if I am, if it's more convenient to take it later, but do we know in this case anything about the investigations that might have taken place about how Bethnal Green girls went? I mean, I haven't, you're reading this, read any evidence at all. Nobody's really looked at that. It's not really
there hasn't been. This is what the Commission found, that there hasn't been an investigation into past failures, for example, past state failures to protect.
Anyway, take us that
Yes.
later. I know that they found credible suspicion of trafficking.
But
it
there's no
struck me that anybody had really looked at, because it wasn't relevant.
No. Mr. Larkin.
So the state might have investigated, might have concluded that no criminal prosecution is possible because the perpetrators were all beyond the jurisdiction. Do we know that?
Well, we know that there has been no effective investigation into this. The Secretary of State hasn't suggested that they've carried out any investigation into this case because they don't identify her. They haven't identified her as a potential victim of trafficking. Mr. Larkin, in cross-examination, said, well, she was outside the jurisdiction and therefore we've put all considerations of Article 4 to one side. So they didn't look at her case through that prism of identification and whether there had been failures.
And at a convenient moment, if you could just give us the paragraph references from the judgment below on this point, that would be very helpful.
Yes, absolutely.
But it is necessary, my question to you is, you say there's been no Article 4 investigation. Is it necessary to look at it through the prism of trafficking? Because there's no doubt that when this happened in 2015 and these girls left, there was enormous concern and interest in an examination of how this had come to pass. That's not good enough, you say, for an Article 4 investigation?
No, because you need to carry out a full investigation to what happened in that specific instance. The background, and as your ladyship has rightly pointed out, that we know that there was a serious concern and problem within Tower Hamlets itself. First of all, another girl in the same school, Shamima Begum, had recently left, and the police were on that case and had written a letter to a number of her friends in the school and asked if they might interview them. And also we have the case of B, Mr. Justice Hayden's case, where he sought to give some sort of guidance because of the concern that there was a real problem, in particular in Tower Hamlets at that time. But there was awareness, obviously state awareness, but no investigation in this case.
What I get, I think, from the passages in the Rants Act 307 to 309 is the duty in her case was to investigate what went wrong, presumably in the hope that future such cases might be prevented.
Exactly right, my lord. And just to be clear, the obligation on Russia to investigate is to investigate what's going on within the Russian state no further. There may be a duty to cooperate with other states to assist them in their investigation. And that is what we're relying on here. There were events leading to Ms. Begum leaving the country, which should have been investigated by the state in this case. And there were state failures at the hands of the police, the school, and the local authority to protect her and prevent her from being trafficked. A particular low line or bright line, depending on the way you look at it, is the risk assessment made by the school before she left, saying that she was at risk of being trafficked, a risk of leaving to Syria. And that did not lead to any preventative measures being taken, as happened in the case of B.
Well, that's the protective. You say there was a failure by the local authority, police, and so on, to protect, given that there was reason to believe that she and others might be being, shall we say, enticed to leave. I'm less clear what you say the investigative failure has been.
So the investigation in this case could have and should have examined what happened, what caused her and her friends to leave the country. What were the events leading up to that? Who was she being groomed by? Who was she in touch with? And should have investigated state failures. So it's in this case, we know quite a lot in one sense about what happened, but of course there's been no investigation into state failure, and that's an important aspect of the investigative obligation. because otherwise you don't learn lessons. If you don't know what the state did wrong, you can't learn lessons for the future. So there's a wider impact of that. There are two domestic authorities in the context of Article 2 and 3, which I was going to reference, not to turn up, but they're in our skeleton, which I'm talking about the wider purposes of an investigation beyond that owed to the victim and the need to examine past state failure. The next case I was going to turn to was SM Croatia. That's in the same bundle, next tab, Grand Chamber decision. And this case I'm going to, because it expands on the purpose of the investigative duty. It was a case concerning forced prostitution, and the Grand Chamber found that the investigation by the authorities was deficient for the purposes of determining whether the individual had been exploited, and therefore there was a breach of the Article 4 investigative duty, and there was a breach of a procedural violation of Article 4 due to a lack of a full and effective investigation. The guidance on the investigative duty begins at paragraph 308. States procedural obligations concerning human trafficking. It's page 2102, and the paragraph I wanted to refer to are all sidebarred 311, 313, and 316. In 311, the court notes that the procedural obligation under the converging principles of Articles 2 and 3 informs the specific content of the procedural obligation under Article 4. And in view of the fact that Rantsev referred to only the most general aspects of the obligation, the court finds it important to set out some further principles. Then 313, the court says that the procedural requirements primarily concern the duty to institute and conduct an effective investigation. As explained in the case law, that means instituting and conducting an investigation capable of leading to the establishment of the facts and identifying and, if appropriate, punishing those responsible. And then 316, the court says the authorities must take whatever reasonable steps they can to collect evidence and elucidate the circumstances of the case. And the conclusions that the investigation must reach must be based on thorough, objective and impartial analysis of all the relevant elements. Failing to follow an obvious line of inquiry undermines to a decisive extent the ability to establish circumstances and the identity of those
So we see that
responsible.
paragraph 315 repeats requirement of means, not of result.
Absolutely, yes.
All relevant elements, do we have any assistance in this decision as to what that means?
All relevant.
All relevant elements, paragraph 316, line 4. Thorough, objective, impartial analysis of all relevant elements.
No particular assistance. It's going to be fact specific. It's going to depend upon the particular circumstances, what leads are available, what happened. But the obligation, the Strasbourg obligation, is very clear that it is a requirement to take all reasonable steps. So the investigation needs to be thorough, needs to speak to relevant witnesses, follow lines of inquiry. In this instance, it would involve speaking to the police, speaking to the school, speaking to the local authority, finding out why they didn't take any active safeguarding measures. They could have put a stop on the airport, they could have spoken to the parents, there could have been an application made to the court, as there was in the case of B. There are a raft of measures which could have been put in place but weren't. So I said I was going to reference two domestic authorities. I won't turn them up due to time constraints, but they're referred to in our skeleton at footnote 7, page 7. The first is the AMIN, which is in Authorities Bundle 1, tab 16. That was concerning an Article 2 duty to investigate death in custody, and Lord Slynn notes that the duty is owed not only to victim next of kin, but to others who may be in similar circumstances. be vulnerable and whose lives may need to be protected. So in other words, there's a wider sort of lessons to be learned, wider state
There was
protection.
a public inquiry after that, wasn't there, into the circumstances in which
I believe there
young
was,
person died.
yes.
Yes,
yes.
that was what we were teeing up to. You had to have a public inquiry into how it all happened. There
Into
wasn't.
that particular case, yes. And paragraph 62 of AMIN refers to the duty to investigate state failures as well as lethal acts perpetrated by the state. And a strong case for saying that an even more rigorous investigation is needed if those responsible for failures are to be identified and made accountable, and the system is subjected to effective scrutiny. So we say that exactly the same requirement exists under the procedural obligation protection in Article 4. You need to investigate state failure. And in similar vein, the authority of AM, which is tab 21 in the authorities bundle. This is an Article 3 investigation which occurred in the context of a riot in an immigration detention centre. And Lord Justice Sedley noted at paragraph 57, the purpose of investigation is to inform the public and government about what may have gone wrong and what can be done to stop it happening again. So in other words, the investigation has a wider public purpose, and it includes state failure. The third authority from Strasbourg is the VCL decision in the Grand Chamber, which is important both in terms of elaborating on the content and purpose of the operational duty and the non-punishment principle. This was a case about two Vietnamese nationals. They were known to fall.
Sorry, tab.
Tab 64.
Thank you.
And it's page 2129.
Thank you.
This is a case about two young Vietnamese nationals. They were known to be a group specifically vulnerable to trafficking. They were prosecuted for the production of cannabis, despite their circumstances giving rise to a credible suspicion that they were victims of trafficking. And the principal complaint, the reference is paragraph 112, the principal complaint by them was that by prosecuting them for offences connected to their work, the state failed in its duty to protect. And the Grand Chamber found a violation of the Article 4 operational duty to protect in this case on account of the failure to identify whether the applicants were victims of trafficking before taking a decision to prosecute. The general principles on the operational duty, which is what I wanted to take the court to, begin at page 2177, paragraph 150, and the first point I want to highlight is that within paragraph 153, and the last sentence of that, over on 2178, notes that protection measures, so the protection which falls within the operational duty, includes facilitating the identification of victims by qualified.
Sorry, I've lost the paragraph.
Sorry,
number. My fault.
it's paragraph 153.
Thank you very much. Yes, thank you.
And it's the last sentence of that. Protection measures include facilitating the identification of victims by qualified persons and assisting victims in their physical, psychological and social recovery. 158, and this is again an important point which is an issue in this case. It's clear that no general prohibition on the prosecution of victims of trafficking can be construed from the Anti-Trafficking Convention or any other international instrument. Indeed, the non-punishment provisions in Article 26 of the Convention and Article 8 of the Directive all contain two important qualifications. The victim of trafficking must have been compelled to commit the activity, and where that is the case, the national authority should be entitled but are not obliged not to prosecute. And they note at the end of that paragraph that there's nothing in either instrument which would be interpreted as precluding the prosecution of a child trafficking victim under any circumstances. So in other words, there's no prohibition, no absolute prohibition on non-punishment, but it must be, the trafficking must be considered when taking the decision whether or not to prosecute. And that is consistent with what we say in this case, and contrary to what the Commission found, that we were arguing for an absolute bar on any sort of deprivation. That wasn't what we argued below, and it's not what we argue in this court. We're arguing that there's been a failure to consider. It is a matter for the Secretary of State to consider all of the relevant components of the Article 4 obligation and form their view as to what the impact of deprivation would be in terms of complying with those, and whether it would be justified if there is detriment or if there is going to be an impediment to complying. But that is a matter for the Secretary.
On the non-punishment principle, and see, and I just want to make sure that I've got it. It struck me as quite a weak principle in that there's no obligation not to prosecute. There's an entitlement merely on the state not to prosecute. And that entitlement would only arise in circumstances where the state was satisfied that the victim was compelled to commit the criminal activity. Compelled, I take it, as a part and parcel of the trafficking status.
Yes,
so that's what you're looking at. Is that
yes,
right?
That's right. That, of course, doesn't apply in the context of a child, where the means, the compulsion is assumed. That doesn't mean to say, and I'll refer to this in due course. We can look at the case of Joseph. That doesn't mean to say, again, as Strasbourg says very clearly, that you can't take a decision to prosecute in the context of a child victim of trafficking, but you do have to analyse and look at whether it's right to prosecute in all the circumstances, and examine the nexus between the acts that you are criminalising, complaining of, and the trafficking.
I think that was my question to you. It struck me that the non-punishment principle, and you must help me, I may not have this right, was not so much an obligation on the state to think about things in a particular way, but a permission on the state not to prosecute in circumstances where there was trafficking and it had led to compulsion or the child.
Well, it's been, if you like, the instruments themselves refer to a permission as a matter of law in this country. As a matter of common law, the Modern Slavery Act, of course, Section 45, has a defence in the context of a criminal case, and the CPS guidance instructs prosecutors to go through the steps and consider whether there's a nexus between trafficking and the criminal acts complained of. So it's not that it's a weak principle, it's an important principle, but with a limit. It doesn't preclude prosecution. That's the important point. What the Strasbourg and the Council of Europe organs are not doing is saying you can't prosecute victims of trafficking. Absolutely not. And we're not saying in this case you can't deprive victims of trafficking of citizenship. It may help if we look further at paragraph 161. May answer
Yes.
your ladyship's question. Given that an individual's status as a victim of trafficking may affect whether there's sufficient evidence to prosecute, whether it's in the public interest to do so, any decision on whether or not to prosecute a potential victim of trafficking should, insofar as possible, only be taken once a trafficking assessment has been made by a qualified person. So that's what the Strasbourg court is saying. And we say the insofar as possible, again, is an important qualification or a caveat. What we're not saying in this case is that there had to be a full investigation prior to a decision to deprive, but rather the Secretary of State had to consider whether its duty to investigate would be impeded by the decision to deprive, and whether that decision was nonetheless justified. So we're not saying that the Secretary of State has to carry out a full investigation before the decision in this case. So,
sorry, could I just invite you to read paragraph 160 as the precursor to 161, which shows what the Strasbourg Court is envisaging might occur, and assumes that the person is present.
So in order for the prosecution of a victim to respect Article 4, his or her early identification is of paramount importance. We would absolutely endorse that. And it follows that as soon as the authorities are aware, or ought to have been aware, of circumstances giving rise to a credible suspicion that an individual suspected of having committed a criminal offence may have been trafficked or exploited, he should be assessed promptly by individuals trained and qualified to deal with victims of trafficking. So the credible suspicion threshold is an important one because it triggers the investigative duty and it triggers an operational duty. It requires the state to take steps. And in this case, in our case, Ms. Begum was within the jurisdiction when the credible suspicion arose, and that required the state to take steps in this case, which it didn't do. So,
Doesn't it, focusing on the non-punishment principle of prosecution of possible victims of trafficking, surely it must depend on the offence for which they might be prosecuted. I mean, if a victim of trafficking arrives in this country and soon afterwards commits a murder, you wouldn't say that the CPS, before charging the person with murder, has to investigate the circumstances of trafficking.
well, they may have to consider, because there may be a direct nexus. The point is, you have to look at, there may be a case of that type of extremity where there is no connection at all with the underlying trafficking. Somebody, for example, let's say somebody was trafficked in another country many, many years previously, many years of intervening events, they arrive in this country and they commit a murder. They don't lose their underlying status as a victim of trafficking. So the CPS is, if the CPS is aware of the underlying facts relating to trafficking, or ought to have been aware, then it must consider those, must consider whether there's a nexus. But in an example where there's an intervening period of many, many years, there may not be a connection, but it's fact specific. But you always have to consider whether or not there is a nexus.
There couldn't have been an assessment here because while she was in the UK, she hadn't been trafficked. She was trafficked to Turkey and beyond to Syria. So that's where you have that's when you would do the assessment. In other words, this is talking about the national referral mechanism and things, isn't it? It's people who are in this jurisdiction who say, I'm only here because I've been trafficked and my criminal activity of which I'm accused is in some way connected with that. That's what this is talking about, isn't it? And the case we're dealing with is completely different.
Well, it's not with respect, because the fact that your trafficking occurs outside does not mean to say, for the purposes of deciding whether you should be criminally prosecuted for something here, it doesn't mean to say the trafficking is irrelevant. It's a question of whether there is a link. That's what needs to be considered.
The only thing that would in practical terms have stopped this case happening would be a B-type application to the family court to have prevented her leaving. The trafficking was her leaving, it was her going.
Yes, or they could have, there could have been an application to the family court, there could have been cooperation with the family, there could have been professionals brought in and engaged, there could have been all sorts of things which could have happened, but measures put in place. An application to the court is one example, but not the only thing that could have been done in this case. Just before we leave VCL, I reminded that I wanted to take the court to paragraph 159,
Yes.
And here the court says, the court considers that the prosecution of victims or potential victims may in certain circumstances be at odds with the state's duty to take operational measures to protect them where they're aware or ought to be aware of circumstances giving rise to a credible suspicion. In the court's view, the duty to take operational measures under Article 4 has two principal aims: to protect the victim of trafficking from suffering from further harm and to facilitate his or her recovery. It's axiomatic that the prosecution of victims of trafficking would be injurious to their physical, psychological and social recovery, and would potentially leave them vulnerable to being re-trafficked in the future. Not only would they have to go through the ordeal of a criminal prosecution, but a conviction would create an obstacle to their subsequent integration into society. And in addition, incarceration may impede their access to the support and services that were envisaged by the Anti-Trafficking Convention. And we say that that's important in this case because there was a credible suspicion that arose before she left the jurisdiction, and that triggered, therefore, the investigative and the operational duties. And part of that was a duty of protect, but another part was a duty, an obligation to assist recovery. And in this case, of course, the deprivation decision will effectively impede her recovery because it cuts all ties with the UK. She can't take the benefit of the social services, the medical services that are available for victims of trafficking here to rehabilitate them. So that has to be taken into consideration. That impediment has to be taken into consideration, and that's what the court is saying here. So turning then to the second heading, and this is the legal obligations that arose in the appellant's case. The factual findings made by the Commission are unchallenged. There is a credible suspicion that she's a victim of trafficking, and there have been arguable state failures which contributed to her trafficking.
There's no finding of that. I just had a look at it. There's no finding of state failures. There is the credible suspicion finding.
Yes, I'm going to just.
There's no. I think it's 224 where the judge says, the SIAC says it's arguable that there were state failures and
that's what she
possible
said,
violations. Sorry, that's what you said.
Yeah.
Yes, my lady.
Could have been investigated.
I was going to take the court to the findings. So in relation to the credible suspicion that the appellant is a victim of trafficking, if we turn to paragraph 218 of the judgment, it's tab 7 of the core bundle. The Commission says the first issue is to decide whether there is a credible suspicion that Miss Begum was the victim of trafficking from the United Kingdom to Syria. And then at 219, in the Commission's opinion, there is a credible suspicion that Miss Begum was recruited, transferred, and then harboured for the purpose of sexual exploitation. And then noting that there's no requirement for the child at the time to prove means. And then in 220, the Commission notes 5 lines down, it's accepted that Ms. Begum was radicalised, although its extent is not accepted, but as a matter of basic common sense, that must have happened at least in part through internet research and grooming whilst in the UK. Her press interviews are entirely consistent with that interpretation.
224 was the next one.
And then 225, the Commission says there's evidence enclosed which also bears on the credible suspicion issue. And then it concludes at 226, the Commission has little or no hesitation in concluding that the credible suspicion threshold has been surpassed, but then says that's not sufficient for her purpose. In terms of the arguable state failures to protect from trafficking, paragraph 92 of the judgment, Commission refers to the evidence that was before the court and the allegation that the police, the school, the local authority, Home Office and security services have been blamed in various ways. And the Commission finds, in our view, putting the matter at its very lowest, there's an arguable case of failing to take reasonable preventative measures directed against the police, the school and the local authority. And that is because the credible suspicion had arose. There would be no arguable state failure if there wasn't a credible suspicion before she left that she was a victim of trafficking. And the going forward, 224, and I'm sorry to jump around, but the findings are sort of scattered, if you like, in the judgment. 224, the Commission says it's arguable in the Commission's judgment that there were state failures and possible violations of the corollary protective duty between December 2014 and February 2015. There is force in the submission that these could be investigated. And then at paragraph 252, and again jumping forward further, the Commission says the Commission's already found that there is a credible suspicion that Ms Begum has been trafficked. Applying the principles in Ransom, there's a credible suspicion that the state's protective duties were violated back in 2015. On the evidence, there's also a credible suspicion that she was harboured by her traffickers until January 2019. This is, and then he goes on to consider what this means in the context of our current ground 2. And we addressed the, as I say, we addressed the UK failures in the skeleton below extensively at paragraphs 10 to 27. Police didn't take adequate action after Shamina, her friend, had left to protect the girls, didn't monitor their social media, didn't speak to their families, didn't raise an alert at an airport. There was no referral by the school to social services for a safeguarding assessment, despite the obligation, obviously, to make such assessment, to make such a referral when a child is considered to be at risk. And that's particularly striking when one reads the school risk assessment of the 10th of December 2014. I'm not going to turn it up, but just for your note, that's the supplementary bundle tab 6, 272, which refers to the concern that Ms Begum may leave home and school, possibly exit the country. There's a chance that she may go to Syria. There's a risk of radicalisation. That was not communicated even to the parents. So the legal obligations that arise, we say, long before the deprivation decision, but certainly by the time of the deprivation decision, the investigative obligation had been triggered, the operational obligations had been triggered, and there is a third category of obligation which I'm going to touch on briefly in a moment, restitutionary obligation, which is a generalised obligation arising under the ECHR more generally, i.e. not specific to Article 4. And we say the first two, i.e. the investigative and the operational obligations, were triggered prior to departure, and the third obligation was triggered as a result of the state failure to protect prior to departure. In terms of the investigative obligation, there were clearly grounds giving rise to a credible suspicion that she was a potential victim of trafficking in 2015. Undoubtedly, by the time of the deprivation decision in 2019, there was clearly a credible suspicion of events which began in the United Kingdom, which would give rise on the part of the UK state to investigate what happened in the United Kingdom. That's a straightforward application of RANTSEV. The investigative obligation has not been discharged because there was no identification of her as a potential victim of trafficking prior to leaving. She's referred to in the ministerial submission as a victim, but it is clear, and it was clearing when Mr. Larkin was examined, that that was not victim, and he was asked this question by Judge Canavan, that was not a victim in the Article 4 or trafficking sense. And it was not, therefore, looking at her as a victim and considering what obligations should be complied with. There's been no full and effective investigation into trafficking, and there's been no investigation into state failures to protect her. The duty, we say, can't be easily discharged whilst she is in Syria. It is already accepted by the Secretary of State that she's unable to participate in any meaningful or effective way in a deprivation appeal, i.e. in these proceedings from Syria. It's hardly a great leap, we would say, to say that she can't she can't participate in a full and effective investigation of the circumstances of her trafficking whilst she remains in Syria. We don't have access to her, and nor does the government have safe access to her for the purpose of taking a statement from her. So that's the investigative obligation which we say is breached in this case. The recovery limb of the operational duty is triggered because there's a credible suspicion that she is a victim of trafficking which arose before she left the UK. And in this case, the Commission has found arguable state failure which occurred before she left the UK. So this is not a case where it can be said that the state did everything it could have done. All reasonable steps were taken to protect her and to prevent her leaving the UK and prevent the trafficking from continuing. And as a result, the Secretary of State, not having discharged this recovery duty, has an obligation to assist with her physical, psychological and social recovery. The fact that she is in Syria will inform the scope of the state's recovery obligations in this regard. What can be reasonably provided, but what we say is really important is that the state cannot rely on its failures to prevent her leaving the UK, the arguable state failure, to say that the duty which did arise, is now extinguished because she's gone. Because that would lead to a situation where it was actually in the state's interests to allow victims of trafficking, where they might otherwise owe them recovery obligations, to allow them to leave and be trafficked out of the jurisdiction because they could say, oh, well, that's it, I don't need to do anything else, they've gone. So the fact that she's in Syria definitely, we say, informs the scope, but it doesn't mean to say that the duty is extinguished. And of course, we say that the recovery duty is of particular importance in a deprivation context, because it will extinguish the possibility of her returning to the UK to be assisted in her recovery. That's not a trump, but it must be considered in order to discharge the Article 4 obligations. I said I would return to deal with the restitutionary obligation where there's been a breach of a convention right. The primary restitutionary obligation where there's been a breach of a convention right is to place the individual in the situation where they would have been had the violation not occurred. In the interests of time, I won't go to the case of Papa Mikolopoulos and Greece, but that's our authorities, bundle 3, tab 59, paragraphs 34 and 36, and it refers to the restitutio in integrum principle, the obligation to put an end to the breach and make reparation for the consequences in such a way as to restore as far as possible the situation existing before the breach, and quotes from the case of Chorzau.
Sorry to interrupt, Ms. Nance. If you're going to refer us to something without taking us to it, which is fine, I understand, but it's in your skeleton argument, it would be really helpful if you can point us to that. Even I found it now, but even the name of that particular applicant I have to look at in order to write down. I think it's footnotes to page 9.
Yes, it's footnote, exactly footnote 9 on page 9, and it's paragraph 16 of the skeleton argument, which sets out the restitutionary obligation. And the principles identified in the Papa Mikolopoulos case are endorsed in a series of other cases which are referred to. I was going to take the court to EZ Tanzania, which is a domestic application of the restitutionary principle in the context of a refusal to leave to remain for a victim of trafficking. And that is Authorities Bundle 1, tab 25, page 542. reparation obligation, which is referred to, has been endorsed by the Court of Appeal in PK Ghana, and that's in our skeleton, referenced in our skeleton, paragraph 16. The discussion for Article 4 purposes begins at paragraph 33. This was a case involving a domestic worker who came in to the UK and was not properly advised in accordance with immigration policy about the risks of domestic workers and trafficking. And it was found at paragraph 42 that there was a breach of her Article 4 rights because of the failure to comply with arrangements to protect domestic workers from the known risks of trafficking. And as a result of her not being advised, and as a result of the breach, she suffered a medical condition, and this was directly linked by the court to the breach of her Article 4 rights. This is paragraph 44, halfway, 6 lines up from the bottom of the page 558. The court says, in our view, Ms. Cronin was correct to submit in these circumstances. A sufficient link has been established between the failure to abide by the protective obligations required of her by Article 4 and the harm which she came to suffer in the United Kingdom.
So is that the point of principle we derive from this decision?
The point of principle is part of the restitutionary reparation obligation where there's been a breach of the convention right. And so if one goes forward to paragraph 67 and the conclusions, at 66 the court notes that the decisions to refuse EK leave and to decline to accept she was in need of protection were made without taking account of the history of events, as we've held them to be. In particular, the decisions were taken without taking account, so in other words, a consideration process of the link between the precarious state of health and the breach of the respondent's own protective obligations in terms of policy in Article 4. And then going forward to paragraph 67, he says, in these circumstances, we find the comments of Lord Justice Carnwath in S, as approved by the Court of Appeal in KA, Afghanistan, to be of value and application. Those are cases which are referred to in our skeleton, which speak to the importance of remedying past breaches. And the court goes on to say it's not open to this tribunal to declare that the respondent must grant the appellant leave to remain indefinitely or for any particular period. It is open to us to determine that a legally material factor in the exercise of the discretion on that matter is the correction of justice. It seems to us that injustice would be done if the appellant were to be returned without having the benefit of the recovery aspect of the reparation to which she's entitled.
And does it make any difference that this case is a removal case?
No, because the jurisdictional link in our case is satisfied because the recovery obligation was triggered whilst Ms. Begum was in the United Kingdom. So the reparation that we are seeking arises out of failures which occurred within the UK.
Is it as simple as this? That somebody is trafficked out of the UK. When that's discovered, is the obligation of the UK government to bring that person back in all circumstances?
That's not what we're saying,
Right.
my lord, and I'll explain why.
How is that qualified?
It's qualified if, let's look again at the Rantz-Saver example. So in that
Yes.
case, there was no credible suspicion that arose before Miss Rantz-Saver
Yeah.
had left Russia. So in those circumstances, then the operational duty didn't arise.
Sorry, somebody is trafficked out of the UK and the state, through various organs, ought to have known about it and taken measures to prevent. But nevertheless, the person goes. Is the obligation to repatriate absolute?
No, it's not an absolute obligation. It's a factor. The reparation obligation is a factor which needs to be taken into account when deciding what the state is doing. So, for example, in the current context, the state wants to deprive, or the state has deprived Miss Begum. In taking that decision to deprive, the state must consider that there is a reparatory obligation which arises, and that must consider whether deprivation will frustrate that. And if so, is there a justification? So it may be, in some cases, that there may be a justification. There could be a case where national security, having considered all of the Article 4 and the ECHR obligations, failure to investigate past state failures, failure to assist protection, recovery. Nevertheless, the state considers all of that carefully when taking a decision and concludes that deprivation is nonetheless appropriate and justified. That's not the situation here, because the Secretary of State didn't consider the Article 4 obligations, didn't consider the impact of past state failures, didn't consider the reparatory obligations. And that is our case in a nutshell. If you like, it's a modest submission in the sense that it's not determining result, it's a procedural obligation. Exactly, it's a procedural. Exactly, my lady. I can now turn, I hope, fairly quickly to the third heading and the relevance of the obligation to the lawfulness of the deprivation decision and to the errors that were made in this particular case. A number of non-contentious, I hope, observations on the deprivation power. It's a discretionary power contained in section 42 of the 1981 Act. What is conducive to the public good requires consideration of a range of public interest factors. It's not just about national security, not just about risk. The consideration to the public good would include consideration of complying with legal obligations towards potential victims of trafficking. And I will very quickly turn up Lord Carr's comment that he makes in the case of Hesham Ali, which is tab 33. It's a second authorities bundle, where he talks about the multifaceted public interest in the context of a deportation, which also has a similar conducive to public good consideration. And what he says at paragraph 169, and of course it's pointed out and that this is a dissenting judgment, but I don't understand what he's saying here to be incorrect as a matter of principle of law. What he says is, much has been said of the public...
Paragraph number?
169, I'm sorry, my lady. It's page 983 for those using the electronic.
Yes.
Much has been said of the public interest in the deportation of foreign national criminals, but the public interest is multifaceted, and there are other important factors which contribute to the positive development of our society and are thus matters in the general public interest. These factors may be a relevant consideration in the Article 8 proportionality assessment and have a freestanding value, independent of that which attaches to the individual facing deportation. For example, there's a public interest in families being kept together, in the welfare of children being given primacy, in valuing a person who makes a special contribution to their community, and encouraging and respecting the rehabilitation of offenders. These factors all play a role in the construction of a strong and cohesive society. They are recognised out with the immigration context, and certain factors given statutory recognition. Where relevant, they should be part of the proportionality equation. Now, obviously, he didn't say there that as part of the rubric of things to be considered is obligations owed to victims of trafficking. But had he been asked, we would say, of course, he would have said that, because there is a very strong public interest in the protection of victims of trafficking, in the prevention of trafficking, and in the prosecution of offenders. And all of those things need to be looked at as a parcel. There's a very clear public interest in preventing and stopping and prosecuting in the context of trafficking. So we say it's hardly a difficult step to say that the public interest would also require, not that it's a trump card, but it would require consideration of trafficking as part of the lawfulness of a deprivation decision. And this, of course, noting that it's an extremely draconian power. Lord Mance referred to this in the decision of FAM at 98. That's Authorities Bundle 2, Tab 1. He noted it was a radical step, particularly if the person affected has little real attachment to the other country of nationality. It effectively severs all ties with the country of citizenship. And as with a decision to prosecute, i.e. the VCL case, or an immigration decision in the context of the EK case and MS Pakistan, which we'll come to look at, the decision to deprive must be taken compatibly with Article 4, where at the time of taking the decision, there's a credible suspicion that the individual is a victim of trafficking. I'm going to turn now to deal with the errors in the Commission's judgment, and I hope I can take these fairly quickly. They are obviously set out in our skeleton.
So just before we get there, I asked you right at the beginning to be really clear about what should have been taken into account.
Yes.
So I think where we have landed up is that you said the Secretary of State should have taken account of the restorative principle, that restoration, well, the fact there had been a substantive breach in the failure to protect in the first place, which gave rise to a restitutionary obligation owed by the state, arguably, and of what you say was an ongoing duty to investigate, and the state should have taken account of the fact that her presence in this jurisdiction would be, at least arguably, part of ensuring an effective investigation. Those are the factors that should have been taken into account, not predicting what the outcome would have been, but if those things had been mentioned, we wouldn't be having this argument. Is that
Yes, and if I can just sort of elaborate a little on that. So what we effectively say is, at the point of deprivation, at the point of taking the decision to deprive, the Secretary of State was required to consider, first of all, whether the appellant was a potential victim of trafficking. If so, what Article 4 obligations were owed to the appellant as a potential victim who's been trafficked out of the UK. We say in this case it's the investigative obligation and the recovery obligation. Then the state needs to ask, have these obligations been discharged? Answer, no in this case. And then thirdly, have there been any breaches of Article 4 such that a restitutionary obligation may be owed to put her in the position that she would have been had she not been trafficked? I.e., had there been any state failures to protect her from being trafficked out of the UK? Answer, yes. And therefore, what, in terms of the reparatory obligation, should the state do? And so that in all the circumstances, taking into account those relevant factors, the circumstances of trafficking, the state failure, the compliance with the Article 4 obligations, together with, of course, national security concerns, of course, risk, always, the Secretary of State has to turn his or her mind to whether deprivation is justified in the circumstances or appropriate. And it's a failure to consider these, which meant, in this case, that the deprivation decision breached Article 4. So I'm going to just deal with the errors that we say the Commission made in its judgment, and based on the submissions I've already made, I hope I can take these relatively quickly. The judgment itself is tab 7 of the core bundle, and at paragraph 244. The last sentence, the judge says, if correct, if our argument is correct, the Secretary of State would never be able to exercise Section 40 power in a trafficking case unless and until a determination were made that the putative victim has not been trafficked or possibly is no longer in a situation. So effectively, the Commission misunderstood our case, thought that our case was that the obligations were imposing some sort of absolute bar, whereas I hope I have made it clear before this court that it is the failure to consider that we're relying on. So it's the procedural protection which is
And that was the way you say it was clearly put to SIAC?
And it was, and for
just give me a reference for that, please.
the reference in our skeleton
Below.
to consideration below. This is a skeleton below, which is tab 4. If the Commission, if this court turns to paragraph 4 and paragraphs 127.
Sorry, of what? The judgment?
Of the
skeleton below.
Of the skeleton below. You'll see that we on the basis of
please.
consider. So paragraph 4 is it's on 84, page 84.
Supplemental.
It's in the supplemental bundle at tab 4. And we said, despite the legal obligation owed to victims of trafficking, when the Secretary of State made his decision to deprive the appellant of her British citizenship, he did so without seeking to investigate and determine, still less consider, whether she was a child victim of trafficking.
Well, you weren't there saying failure to consider.
We were saying consider. We're saying two things, if you like, but we were saying consider.
That paragraph's fairly read on one view at least, says it's a failure to investigate and determine.
Without
It goes
seeking.
on to say still less consider, I
Yes.
see.
And it's 1 to 6 and 7 going forward. Sorry, 1 to 7, page 143. In the context of VCL, we make it clear that there's no absolute bar on individuals being prosecuted for their actions, even if they are connected to having been trafficked. However, as the Grand Chamber also made clear, a decision to prosecute taken without at least considering a person's status as a victim of trafficking breaches Article 4 of the Convention. So it was put on the basis of consideration.
Well, there's quite a difference, isn't there, between failure to consider and failure to investigate. Failure to consider might be the Secretary of State on the materials presented gave no thought to the issue of whether the client may have been the victim of trafficking. Failure to investigate is much further, isn't it? You're saying that no deprivation decision could properly be taken until and unless there had been an investigation.
That's not what we're saying. So we're saying that in taking the decision to deprive, the Secretary of State has to consider whether deprivation will impede or frustrate the duty to investigate. How will the decision to deprive impact on its duty? It has this duty to investigate. It's up to the state, obviously, to decide how it discharges that duty. It has scope to determine that, but what it has to do in the context of the deprivation decision is consider whether the deprivation decision will mean will have an adverse impact on the duty to investigate. And if so, if it does have an adverse impact, which we say it does, then it has to consider whether it would be justified in all the circumstances of the case. In other words, is the national security case one that means that it would override the obligations in that particular case? But we don't, in this case, have the consideration. That's what this is why we're focusing on the breach.
Am I right in understanding them tonight that in any case that's involved national security considerations weighing off against potential arguable breaches of Article 4? So the justification, Lynn, which I know you say you never got them there, in this case because the considerations were never fed in, but it is quite important to the way we look at the case. Is that just something of your own intuition? Is there any authority that tells us how, in a convention case, you weigh off national security considerations?
Well, I can perhaps, yes, deal with that. But ultimately, in this particular case, it doesn't arise because there wasn't a consideration at all. But it's essentially a matter for the Secretary of State to weigh in, to balance the factors. What we're not doing is usurping the Secretary of State's ability to assess national. We're not intruding on that assessment. We're saying there are factors that weren't taken into account.
It's ground 2.
Well, that's under common law.
The two merge together.
Yes, under common law, there's a separate argument, which is a sort of a different legal test, a rationality test, rather than an Article 4. So that's the first error, that there was no consideration of the Article 4 obligations. They weren't considered to be relevant. That was very clearly put in the Scott Schedule, which is the supplemental bundle, tab 3. And the policy relating to minors of the 31st of January effectively also precluded such consideration. That's set out in the judgment at paragraph 130. So the starting position is that the Secretary of State considers minors assessed to have been radicalised as vulnerable victims, and then that leads on in paragraph 4. It says at the bottom, our general view is that it's reasonable to consider that as a minor, such an individual will be more at risk of radicalisation, less able to resist manipulation than an adult. For this reason, we consider that individuals who've been radicalised as minors should be considered as vulnerable victims, but it apparently is taken against them because they're considered to be more at risk of radicalisation. But then at paragraph 19, where the minors reach the age of majority, but there's a national security case against them to justify deprivation, and that's based on their actions as a minor, we will recommend deprivation. While such individuals may once again be considered as a victim, perhaps having been radicalised or compelled to travel to Syria or Iraq as a minor, this does not alter the assessment that will have been carried out as the threat they now pose to the UK. And then there's a sort of carve out, if you like, to that sort of binary. Anybody who is considered to be at risk, it's irrelevant that they were radicalised as minors. There's a carve out. They say we would continue to explore carefully any information to suggest that an individual who had not travelled to theatre as a minor of their own volition and had not been involved in further activity of concern is now, as an adult, seeking to distance themselves or escape from an ISIL AQ group. As with other cases where such information exists, it will be included in the advice put before you, as this could provide a basis for holding back from deprivation action. There was no carve-out in this case because it was assessed by the Secretary of State that she voluntarily travelled of her own volition. So she didn't fall into that category. The next error we say is 228 of the judgment. And we say the error here is that the Commission thought that what was required in order for us to succeed was an obligation to repatriate, a freestanding obligation to repatriate. That's the last sentence, two sentences on paragraph 228. And we say that's not what we say, and not what we said below. The case of MS Pakistan was an immigration case where as to whether removal was appropriate in the context of an investigation which had not taken place, and the consideration was whether or not removal would breach Article 4 because it would not be possible to carry out the investigation. And we say, by analogy, in the deprivation context, one would need to consider whether deprivation is appropriate and whether it would frustrate the investigatory duty. But what the court did not find in MS Pakistan was a breach on the basis of any Article 4 freestanding right not to be removed from the UK. It was entirely tied to the need to comply with the persisting investigative duty. If we can just turn that case up, it's tab 47. So
just before we do, you said the second error made by SIAC was at paragraph 228, and we've been looking at 228, but you didn't say what the error was.
If we go over the page on 141,
yes.
He says a violation of Article 4 would occur only if the Secretary of State were under an obligation to repatriate her for that purpose. Now, below, there was a completely separate argument, an argument under Article 16 of ECAT about repatriation, which is not pursued before this court. And it seems as if there was some confusion in that context as to what was being contended for under the Article 4 argument. But we do not contend and never have contended that Article 4 entails a duty to repatriate. There is a duty, operational duty to protect and recover for the state to decide how those are to be discharged. There is no freestanding duty to repatriate. The MS Pakistan case is in tab 47 of the second authorities bundle. There were two issues in the case. One was whether or not the court was able to determine for itself, contrary to the competent authorities, whether somebody was a victim of trafficking held yes. And then the second was whether there was a breach of the Article 4 obligation. And Lady Hale at paragraph 35 says this: however, it is clear that there has not yet been an effective investigation of the breach of Article 4. The police took no further action after passing him on to the Social Services Department. It's not the task of the NRM to investigate possible criminal offences. The competent authority may notify the police if it considers offences have been committed. The authorities are under a positive obligation to rectify that failure, and it's clear that an effective investigation cannot take place if MS is removed to Pakistan. The upper tribunal rightly held that it's inconceivable that an effective police investigation and any ensuing prosecution could be conducted without the full assistance and cooperation, and realistically this will not be feasible if he's removed to Pakistan. So on the facts of that case, there was found to be a breach because the investigation couldn't take place effectively. But to your ladyship's question earlier, there may be cases where an investigation can take place without the participation.
With MS Croatia, then what I've got in my head is the idea that the state has to take reasonable steps. So it might be said, that it's reasonable if somebody's within the jurisdiction to keep them in the jurisdiction, and depending on the context, have your investigation. So that's obviously a ball that we need to keep our eye on, isn't it? Is the sort of reasonableness gauge which plugs into the investigative duty.
Yes, absolutely, and
Case where it fell out that way.
yes, and yeah, one needs to look at the scope of the obligation in the context of that. We accept that. And yes, in this case, the appeal was allowed and the decision of the tribunal was restored. So the Secretary of State's skeleton merely adopts the finding of the Commission that there is no duty to repatriate. But as I say, that's based on a misunderstanding of NS Pakistan. Thirdly, paragraph 236, we say there's an error in the analysis of the recovery duty. So what the Commission said in the last sentence is that by February 2019, the state was no longer in ISIL-controlled territory, and in a case such as the present, we cannot accept that the Secretary of State would have been or is under an obligation to take positive steps to bring about her return to the United Kingdom within the terms of any recovery obligation. And we say that the fact that she was no longer in ISIL-controlled territory doesn't extinguish the recovery obligations towards her as a potential victim of past trafficking. The recovery duty arises here because there was a credible suspicion which arose prior to departure, and it isn't extinguished because the victim of trafficking moves to ISIL-controlled territory. And the Secretary of State in their skeleton simply, again, relies on there is no duty to repatriate, but this ignores our core argument, which is that deprivation impedes the ability to discharge the recovery obligation, and that this needs to be weighed against or weighed in the balance with the other factors, including national security. The fourth error, we say, is in relation to the non-punishment principle, and this the Commission dealt with at paragraphs 240 to 246 of the judgment. The domestic law principles in terms of what one can derive from Strasbourg law, this is the AB decision and Rabone decision, obviously are well established. In AB, this is Authorities Bundle 3, tab 52, at paragraph 59. It's not the function of a court to establish new principles of convention law, but that's not to say that they cannot develop it beyond the limits of Strasbourg. The court should anticipate how the European Court might be expected to decide the case. And we rely, for this non-punishment principle, on the Strasbourg decision of VCL. That decision obviously arises in a criminal context, but it's the rationale that the court gives for the non-punishment principle as being linked to protective and recovery obligations. That's for your note, paragraph 159 of the judgment.
Sorry, it's my fault. You've lost me. In paragraphs 240 to 246, there's further error. You've taken us to 244. What is the error in 240 to 246, do you say?
It's essentially the finding that the Commission can't be confident and that there is that the non-punishment principle would be applied to a non-criminal context. So he's looking at whether or not it is confined only to the criminal context.
That's our 246, really, isn't it?
Yes, exactly.
You say that's wrong
We say
because
that's
of the way it's put, the Grand Chamber put their judgment in VCL.
Yes.
Although VCL is a criminal case, I appreciate one mustn't boil AB down to saying never do anything for the first time, but is there in fact a case in which the Strasbourg Court has held that the non-punishment principle can be applied to state action, which is not prosecution of criminal conviction?
There is not, my lord. Otherwise, I hope we would have.
Mhm.
I did.
Yes.
Well, we're not aware of it.
It would be
And I hope I would
amazing
have
if the
started with
galaxy
that.
of talent had.
Yes, rather than VCL.
Yes.
So we do rely on VCL, and it's in fact the one of a relatively few Strasbourg cases which actually examines in some detail what is involved in the scope of the non-punishment principle. And it is as I say, paragraph 159 of VCL, where the principle is linked to the protective and recovery obligations, which we rely on, because we say that those recovery and protective obligations would apply equally in a deprivation context, because deprivation effectively extinguishes the relationship with the state. We do also rely and say, consistent with this analysis of VCL, there is a range of other international law instruments, including the OHCHR, Office of the High Commission of Human Rights Trafficking Principles, Article 25 of ECAT and Article 8 of the EU Directive, and those refer to penalties. The fact that the state may consider not imposing penalties as well as non-prosecution. So we say it's clear that it goes beyond the criminal context. And if you think about the impact that criminal law, prosecution and deprivation may have, effectively both are looking at a public interest and whether it's in the public interest to prosecute, whether it's in the public interest to deprive. Both are based on some kind of assessment of culpability for wrongful conduct. Both are in their effect, even if not intended, but both are punitive in nature. And of course, the Commission observed at paragraph 2.1 of the judgment that the consequences of deprivation are more severe than a long prison sentence. So we say that the principle can be extended. The Secretary of State's skeleton, and I'll just deal with the arguments there briefly. The Secretary of State's skeleton at paragraph 23 relies on the fact that criminal law is focused on punishment, whereas deprivation is focused on risk. But of course, criminal law may also focus, and certainly in terms of sentencing, on risk mitigation and public protection. As we've already noted, deprivation is a very radical step. It's punitive in effect, even if it isn't imposed as a punitive measure. We say it doesn't matter because of the AB authority that there is no direct authority on this point, because it flows naturally from the Strasbourg decision in VCL. And we say there's no principled basis for saying that it shouldn't apply in the context of deprivation. Then the final error was in the SIAC judgment was to fail to recognise that the Secretary of State should have considered the state's reparatory restitutionary obligations arising from the historic breaches of Article 4 duties when considering deprivation. So paragraph 238 the Commission says, turning now to the protective duty, the state may have failed in its duties to Miss Begum before she travelled to Syria, but she is now well beyond the scope of its protection. And further, to the end of that paragraph, over the page on 143, the Commission says there must be a direct connection between the exercise of the power and the violation of the right. And what happened in 2015? What happened in 2015, even if a past injustice falls to be remedied or at least recognised, does not provide that connection. We say that's wrong to hold that what happened in 2005 doesn't provide that connection, because there was a credible suspicion. It triggered the operational obligations, the recovery duty, and therefore the Secretary of State needed to give careful consideration as to whether state failures to prevent the trafficking should mean that the effect of trafficking should be reversed by allowing her to return to the UK. And again, we emphasise that we're not saying that the Secretary of State was obliged to repatriate as a consequence, merely that the Secretary of State had to consider the restitutionary obligations. And then finally, on ground one, I'm going to deal with the jurisdictional arguments. I've actually already, if you like, dealt with these in the course of my submissions, in particular in dealing with Rantsev. The Secretary of State argued below that Ms Begum was outside the territorial jurisdiction of the UK, so that no issue under Article 4 could arise. We say Secretary of State is wrong in principle and contrary to authority, and that the Commission's finding of fact are the starting point for the jurisdictional link for Article 4 in this case, that trafficking was a process which began in the UK prior to her leaving, and that before she left, the credible suspicion had been triggered that she was a victim of trafficking, and there were state failures. And the Commission did hear
arguable. I mean, you keep saying state failures, arguable state failures.
State failures. Thank you, my lady. The Commission did hear argument on jurisdiction and rejected those arguments, and that's at paragraphs 187 to 188 of the judgment. He deals at the Commission deals at 187 with the fact that, looking at the Rantsev judgment, the fact that Ms Rantsev was in Cyprus at the time she died did not constitute a jurisdictional impediment. And then they say we can deal quite shortly with Sir James's submission that at paragraph 289, the court referred in terms to the investigation of criminal offences, and none were committed in the United Kingdom. This takes too narrow an approach. And then 5 lines up, he says there's no sensible reason why any such investigation should be out with the scope of Article 4. That's just a straightforward application of Rantsev. So he did deal with it, contrary to the Secretary of State's submission that in their respondent's notice that the Commission didn't deal with it. And we say there's a distinction between Article 1 extraterritorial cases where you need to fall within one of the exceptions, diplomatic, an army base, an embassy, and in cases involving some sort of international element, but not an extraterritorial exercise of jurisdiction. So this is a case about a jurisdictional link, not an extraterritorial exercise of jurisdiction. And it's a straightforward application of Rantsev. And we do say that, given the analysis of the court in Rantsev about the operational duty, that had there been a credible suspicion in that case, they would have considered the operational duty under the rubric of Article 4, notwithstanding the fact that she'd left the jurisdiction. So those are my submissions on ground 1,
Yes.
and I'm going to turn to ground 2, and I anticipate I'll finish my submissions on that before lunch.
Good.
And then hand over to Mrs. Squires. Ground 2, I can take much more swiftly. The argument is set out in our skeleton core bundle 2, page 15, and sorry, I've been trapped by a chair. Thank you. So the first error was, we say, to make the finding that it did, and it's a sort of, the analysis is contained in paragraphs 248 to 261 of the judgment, where the Commission concludes that the fact that Ms Begum was a potential victim of trafficking, the fact that state had failed to investigate her trafficking, and that there were arguable state failures were not obviously material factors militating against deportation. it's common ground, I believe, that Section 40 of the 1981 Act involves consideration of whether to exercise a discretion, involves a holistic and individualised assessment and consideration of applicable rights under the Convention. All relevant considerations, we say, must be taken into account, and those which are so obviously material. And just turning up the YH decision, which is tab 22 of the Authorities Bundle 1. This is a decision of Court of Appeal Lord Justice Carnworth giving the judgment. And, it's about anxious scrutiny involved in cases involving human rights or fundamental rights. And he says halfway through paragraph 24, it's by usage acquired special significance underlying the very special human context in which such cases are brought, and the need for decisions to show by their reasoning that every factor which might tell in favour of an applicant has been properly taken into account. I would add, however, echoing Lord Hope, that there is a balance to be struck. So we say that, especially in the context of deprivation decision, given its draconian effects, that it's axiomatic that all relevant considerations must be taken into account. We also say that it is relevant to consider whether there is a need to correct past injustice, and we rely on the authority of S at paragraphs 46 and 69. That's Authority Bundle 1, tab 19. We also rely on the Hesham Ali Lord Carr observation that the public interest is multifaceted, and we say that compliance with legal obligations owed to victims of trafficking is a matter of public interest. And we note in the criminal context the careful consideration which is given to trafficking and to the legal obligations prior to a decision to prosecute. The case of Joseph is Authority Bundle 2, tab 36. And the relevant paragraph is 21. This was a case that arose before the Modern Slavery Act statutory Section 45 defence, and it says that as a consequence of experience in the decisions of the court and successive changes to CPS guidance, the present policy of the CPS is to require the prosecution to consider three broad questions on a fact-specific basis in each case, where the defence of duress does not arise on the evidence. Is there credible evidence that the defendant falls within the definition of trafficking? Is there a nexus between the crime committed by the defendant and the trafficking? And then in the case of adults, it's necessary to assess whether the defendant had been compelled to commit the trafficking. Is it in the public interest to prosecute? There will be some crimes that it will be in the public interest to prosecute. And then it says, the policy makes clear, this is paragraph 22, that in the case of children, the position in relation to the second question is different. As we set out at paragraph 37 below, it is a sufficient nexus that if the offence is a direct consequence of the trafficking, it's not necessary to show compulsion. And so we say basically it was an error for the Commission to conclude, as it did at paragraph 259 of the judgment, that the fact that Ms. Begum was a potential victim of trafficking and there may have been state failures connected to that trafficking were not so obviously material to that assessment. And so we say that even if the court, in this case, isn't with us on ground one, and doesn't accept the fact that Article 4 will have been breached if there's no consideration of the legal obligations prior to deprivation, they you do have to consider whether it was irrational, not as a matter of public law, not to consider these legal obligations, and we say it was. Then looking at the second limb of our ground 2 argument, we say that the Commission erred in failing to conclude that the fact that the appellant was a victim or potential victim of trafficking was obviously material to an assessment of her national security risk and was not properly considered by the Secretary of State. So here, the challenge against us is that risk and national security are just absolutely off limits. You can't say anything about the way that that process was conducted. We say we're not seeking to impermissibly intrude on the national security assessment, but what is incredibly important is to take into account relevant considerations relating to trafficking which impact on that risk assessment. So in this case...
So how is that not intruding on the risk assessment?
It's a sort of consideration of factors. We're not saying to the Secretary of State, you have to decide in this particular, it's not a result-led conclusion. It is a process argument that when looking at risk, you cannot, in the context of somebody who's a potential victim of trafficking, you can't divorce that from considering what that means in terms of...
You are telling the Secretary of State how to assess risk. You're saying this is the procedure you must adopt.
We're saying these are factors that need to be looked at.
So why are you not intruding on the risk assessment in that sense?
If we are intruding, it's a very minor intrusion. That's one that's permissible. What we're not doing is predetermining a result of the exercise. Thank you.
And why is it relevant to risk?
It's relevant to risk in a number of ways. First of all, the fact that somebody has been trafficked may be relevant to their personal responsibility. So therefore may be relevant to the specific acts which are alleged to form the basis of the national security exercise. It's also relevant to alignment, whether or not somebody in fact was truly aligned, or whether in fact they were groomed, coerced, encouraged, along with all sorts of incentives, offered things which meant that they weren't in fact truly committed to the cause. And thirdly, it's relevant to the consideration of future risk, rehabilitation. If somebody has been trafficked and they are offered rehabilitative and recovery and assistance, then it will have an impact on their future risk. So these things need to be looked at through a prism of trafficking. And the national security assessment was based on 3 key elements, we say, which were relevant for in terms of looking at them through a trafficking lens. First of all, the voluntary travel to Syria. Secondly, the fact that Ms. Begum remained in ISIL-controlled territory until January 2019 and did not attempt to escape. And then the statements made to the press shortly after she left ISIL control. And when one looks at the National Security Assessment, which is at Supplementary Bundle 20, and the open summary of decision at tab 21, and the amended National Security Statement, those 3 elements feature...
sorry, can you slow down again?
Sorry, I'm sorry.
No, don't worry at all. So, you said there are 3 elements?
There are 3 elements, 3 key elements that the National Security Assessment is based on in this case. One is her voluntary travel to Syria.
Yes, I have that. The fact she remained in ISIL-controlled territory and didn't
attempt to escape.
And her statements to the press after
statements to the press. And we say when one looks at the 3 decisions, those 3 elements are key to the decision making in this context.
Thank you. And the 3 decisions are
the National Security Assessment, which is tab 20 of the supplementary bundle. the open summary of the decision at tab 21 and the amended national security statement at tab 26.
Thank you.
I've understood that the focus of your arguments here is that the fact that she was trafficked would and should have been taken into account as an exculpatory factor. In other words, it could explain why she travelled to Syria, it could explain why she stayed in controlled territory, and it could explain her press statements. And I understand that, but it is also possible, isn't it, that it could in fact inculpate her because the trafficked individual she might still have been a voluntary traveller. I mean, she may be more dangerous because she's been trafficked because of the consequences that might have had upon her. So it doesn't necessarily all go one way. It could, it cuts both ways, I suppose.
Yes, absolutely, and I accept that point entirely. But it must be considered. One must consider those elements in the light of trafficking and the available material that is well known within the government circles. So there was a considerable body of unchallenged expert evidence in this case. I'm anticipating that you've read the relevant passages in the skeleton below. That skeleton below, we could just turn it up and I can just refer to it briefly, but it's tab 4 of the supplementary bundle, and the relevant passages are 100 to 115. And what these passages here do are take, if you like, those three elements, the consideration of travel being voluntary, the fact that the appellant remained in ISIL territory until January 2019, and the statements made to the press, and they analyse those through
I haven't got tabs, so just a page number, please.
I'm sorry, page 130
Thank you.
of the supplementary bundle.
Thank you.
And so what the experts do, and as I say, there was no request to cross-examine the experts, their evidence was accepted before the Commission, and the Commission makes that finding. The experts, if we look, for example, on page 132, Dr. Kozinski, this is paragraph 103, 4 lines down, Dr. Kozinski explains adolescents are particularly vulnerable to certainties in the form of religious cults, influence peddlers, or promise certainties a trafficker presents to his or her potential victim, and are more vulnerable to coercive pressure than adults. And then he further says it's well known, this is the last 2 sentences, that the recruitment strategy at the time of travel involved a well-organised online propaganda campaign. And then he goes on to say, this is the last sentence, reviews of the historical, neurological and developmental vulnerabilities typical of many child trafficking victims have real serious doubts regarding their ability to control their choices or escape from their trafficker. And Dr. Green, separately in another report, refers to the well-established evidence on the teenage brain, the enhanced vulnerability to risky behaviour. There's a link made between the adolescent's brain development and increased vulnerability to risky behaviour. And so, and the conclusion we draw to paragraph 105 is that the failure to consider the appellant as a child victim of trafficking and the repeated characterisation of her travel as voluntary without the recognition of ways in which adolescents can be groomed failed to understand the nature of the travel, and this prism was critical to an assessment of the.
So it actually goes a bit further than just saying they needed to take into account the material factor that she had been trafficked. There's more than that. You bring lots of analysis and expert evidence in as well. I think all of it is part of your case, that the Secretary of State should have considered whether these factors were at play in her particular case, and only reached a conclusion on whether her presence or absence was conducive to the public interest once all that had been taken into account.
Yes, they should have at least. I mean, this was not, as I say, material that was out with the knowledge of the government. There is numerous references to the propensity of children to be particularly vulnerable within modern slavery guidance, within the materials that the Secretary of State, which the government itself has. Those are footnoted, for example, on page 50 of our skeleton, at footnotes 1, 2, 3 to 127. So
it really isn't a question of expert evidence at all, is it? You just say that the regard that should have been had was to material that's well in the public domain, some of it emanating from government. So whether you're Dr. Green or Kozinski says it doesn't really, that's really beside the point, isn't it?
It's sort of, if you like, belt and braces, because it was all information that was before the government, and the government ought to have known. Similarly, going forward to 106, the reliance on the fact that she remained in the territory until January 2019. 107 refers to whether this is Kozinski again, no consideration of whether the appellant had the cognitive capacity to formulate a strategy, to flee, manage risks of doing so, formulate a plan. And he makes reference, this is going over the page, to the identificatory acceptance of and submission to overwhelming power, the concept of learned helplessness, so that even if somebody can actually escape, victims of trafficking don't always escape because they have been subjected to a coercive power situation for and so they have this sense that they might not be able to survive on their own. And then
I misunderstood something. I thought one of the points you were making in the skeleton was that the question of whether the travel was voluntary was simply a question of fact which SIAC were bound to determine, and they shouldn't have deferred the Home Office because it's not a matter of special knowledge or expertise, but you seem to be saying, which certainly how I would have thought of it, that it is, to some extent at least, a matter of expertise.
well, it's something that it's not a matter of expertise, but I think our expert opinion, if you like, assisted in terms of understanding how one examines voluntariness. But as Lady Justice just pointed out, in fact, the expert evidence was, a fortiori, but in fact all the material was there before the government. But it's for the Secretary of State can and has the information available to understand what is meant by why somebody travelled. The reason why somebody travelled is a prior consideration to the risk that they might present, and the reason why somebody travelled, the factors that go into making somebody travel and whether it can be said to be truly voluntary are matters which needed to be considered. But here, it doesn't. There is no examination looking at it through a trafficking lens of the reasons why a 15-year-old child living in Tower Hamlets may, seemingly on her own with two friends, go to Syria. So to treat it as a sort of voluntary travel. First of all, in any event, she's a child victim of trafficking. But secondly, leaving that aside, one still has to consider how she's been groomed, coerced, and the pressures that she's been subjected to examine whether or not it was a real choice. And that is a relevant consideration in looking at the national security case and the assessment of risk.
Could you look at SIAC paragraph 257, where they deal with this? And just tell us what in that paragraph do you accept, obviously not the first sentence, but the rest of it. What do you accept and what do you take issue with?
finding that the Commission can't accept that the Secretary of State should be compelled to view the case in these terms. So effectively, what I understand the Commission to be saying is that the Secretary of State's argument that national security and risk are entirely a matter for us to form our own decision on, and trafficking is the fact that she's trafficked is not relevant to that. The Commission accepts that as an argument, and that is what we take issue with, because it, for all the reasons set out in our skeleton argument below, fails to understand the true nature of whether somebody is voluntarily travelling, whether they are by choice remaining in a situation or in the ISIL-controlled territory situation where they are under the control of traffickers, and whether they have and it takes at face value, if you like, the statements to the press.
Okay.
And that's what we say.
Would you accept that voluntariness is not a binary question? I mean, nobody's suggesting that Ms. Begum was physically killed, so it was voluntary, at least in the extent, to the extent that we walked up the steps onto the plane and so on. But it isn't 100% or 0% voluntary, is it?
No, we absolutely accept it's not a binary question. It is a nuanced. All of these elements were nuanced questions that needed to be considered, and they needed to be looked at through the prism of what is known in the public domain to take effect with people who are trafficked. What are the impacts of those who are trafficked? How do they behave when they're in a coercive situation? Why don't they leave? Is that to be held against somebody, such as Miss Begum? It was held against her in this case. Statements made to the press shortly after she left the situation of trafficking. Is she really a free actor, a free agent, when she's making those statements to the press? It's those sorts of questions that, if one looks at this through the trafficking lens, one has a holistic picture. These are relevant considerations. They may not trump national security, but they are considerations which need to be looked at.
But you're not saying that, I mean, the open submission, the open summary of deprivation submission at page 742, you're not saying the possibility of radicalisation or her age were ignored, are you?
No, they weren't ignored, but they weren't factored in through a trafficking lens.
Well, what would a... Right, so I'm looking at entry E on that page.
Sorry, page
742, letter E.
Yeah, so
and if you look at the other, the attached Annex A and all that, I mean, is it just the words used, or is there a substantive error here?
we say there is, and in part as a result of the minors policy, which I referred the court to earlier. So what we say in E, for example, is that it's the fact that somebody in Miss Begum's situation may have been radicalised as a minor and therefore may be considered victims does not alter the threat that the security service assesses she poses. So in other words, they say on the one hand, well, she may be a victim, but that doesn't matter at all. It's irrelevant to risk, because what we're looking at when we're taking the decision to deprive is simply risk. We don't need to take into account the fact that she was a victim. They're not looking at it through the more nuanced lens.
It doesn't matter what you call it, surely, but What they are looking at is whether she poses a risk, as I read it, notwithstanding the fact that she was radicalised and is a victim. Minors policy is even clearer on that. I think you start from the position that if you've got a minor and they were radicalised, they were a victim and they are a victim, and that's the starting point. So what extra thing is it that you get by saying it's not just a question of victimhood, it is a question of looking at trafficking context? What's the extra bit that should have gone in?
Well, it's all of the material that's in the in paragraphs 100 to 115.
Expert evidence isn't the issue. You can't expect the Secretary of State to have consulted your experts in advance of you. So we have to be looking at commonly accepted understandings, is this right, of people who've been trafficked. But you say it's not enough, it's not sufficient, it's not adequate simply to refer to them as victims who may have been radicalised. There's sort of something else in there as well.
Yes, one needs to understand why they did what they did. One needs to look at it through the prism of a 15-year-old girl.
But they are doing that. They've got age on board and they've got victimhood on board. They've got all that on board.
They haven't given any consideration to the risk that a 15-year-old might take because of being 15, because of the adolescent brain.
The cognitive
ability. They take no account when saying that she didn't leave. She could have left, she didn't leave, of the types of impact that being in the situation that she was had on her. That it wasn't realistic. It wasn't within her cognitive ability for her to leave. So there's no nuance. It's a binary. And of course, the minors policy, as I said, makes it clear that the victim, the fact that she's a victim, and they do not look at her through the prism of being a victim of trafficking. Judge Kavanagh specifically asked Mr. Larkin that in cross-examination. What do you mean by victim? In fact, it might be useful just to turn up what...
I'm looking at the policy on minors. Our starting position is that we consider minors assessed to be radicalised to be vulnerable victims. So the victimness or victimhood is in the context of whether they've been radicalised. And it says that if you're young, you're less able to resist such manipulation. So they have got youth on board, at least in that prism, which I understand you to say is not the right way of looking at it, but I suppose I'm just asking you to tell me, so what didn't they put in? Well, short of going to your experts.
Everything that our experts said about the adolescent brain, about the reasons why young people take risks, about why they are persuaded to do things which involve travelling to Syria, the impact of the social media. And that, of course, we says it is relevant to the assessment, the national security assessment, because it is relevant to risk. If she was persuaded and coerced, she may, and given support and assistance after the event and recovered, she may not be such a risk. She may not be such a future risk. But if you don't consider this, then that's the error. We say, if the Secretary of State had considered all of this, then it would be a very different type of argument. We wouldn't have the argument of failing to take into account mandatory relevant considerations in the same way. There may be an irrationality argument, but this is a sort of straightforward, failed to take into account things which, in relation to trafficking, were well known to the government and should have been taken into account.
On page 812, the extract.
Sorry, my lord, I'm just getting there.
Sorry, yes. You'll recognise it when you get there. 31st January 2019.
Yes.
It's much quoted in other documents.
Yes.
I mean, that says that describes individuals who've been radicalised and travelled to Syria. Are first and foremost victims, and it goes on to explain that as a minor, more at risk of radicalisation, less able to resist manipulation, and so on. I appreciate there's no mention of trafficking, and certainly not trafficking for the purposes of sexual exploitation. But that apart, it puts the case for the individual pretty well, doesn't it?
Well, we say it doesn't because of what the policy is actually doing. So but if one looks at paragraph 19, halfway down, whilst such individuals may once again be considered a victim, perhaps having been radicalised or compelled to travel to Syria, Iraq as a minor, this does not alter the assessment that will have been carried out as to the threat they now pose. So in other words, the assessment of risk and the threat that they now pose is without regard to all of the factors that we say needed to be taken into account when assessing a 15-year-old girl. And
She's 19 now. When this happens,
yes.
she's 19.
Yes.
So I'm putting it, I recognise a little bit too baldly. The components that ran into the risk assessment were those to do with 2015 and why she left. And she did quite a dramatic thing by leaving, by packing her bags and going. So that was, that's quite striking. And then it's the staying, it's what happens in the 4 years since, isn't it? So it's that combination of, that's the assessment, that's the evaluation that needs to take place. So it isn't just a question of, so it isn't ignoring the fact that she might have started out as a victim. It is a much more multifactorial analysis, isn't it?
Well, we say that that it's effectively what this policy is doing is creating a sort of a binary. You know, if we think you're a risk, we think you're a risk, and we're not going to look into how you came to travel, what happened to you whilst you were there, and whether or not it was realistic to say that you left completely as a free agent, completely by free will, or whether you remained in the territory by choice, because obviously for some of the time she was an adult. She was, of course, mostly pregnant at the time she was in the camp, but she was under the control of traffickers. But none of that appears because this policy basically says it's, you know, where you've got somebody who has travelled as a minor and was taken as a minor, a non-voluntary taking as a minor. This is the paragraph 120 in the judgment, and they left the territory and they've sought to distance themselves. Then that might be taken into account. So, so they say they will take this sort of a more nuanced approach if somebody had not travelled as a minor of their own volition, had not been involved in further activity, and is now an adult seeking to distance themselves. So that's a very narrow category of people that they will take a more nuanced approach. But for everybody else, including Ms. Begum, who didn't fall within that narrow category, they just essentially assess her risk without looking at it through a trafficking prism.
Thank you.
I don't think I can say any
you've
more on that. May I just make sure that I've said
yes.
everything I need to say?
Yes. You've got any questions on grounds 1 and 2? Any questions on grounds 1 and 2? No.
That's all.
Well, thank you. You've been very patient in dealing with our several questions. So thank you very much for your assistance. Mr. Squires, would you like to start now, or would you prefer to start at 10 to 2?
Maybe 10 to 2, if that's okay with the
Okay
court.
with
But I mean, I can stop now as well.
All right, 10 to 2. Thank you very much.
Court rise is able.